Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year.
Quick legal insight here. This is the standard Miranda rights warning. Judges repeat this in court to protect the defendant's rights and to make sure nothing said can later be tossed out on appeal. But notice the tone, it's already setting the stage for some serious drama in this case.
You're in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with complaining witness one, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The first complaining witness stated the defendant had struck him in the face while the defendant had a phone causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness one was trying to calm down the situation, the defendant struck complaining witness one in the face, and in the process of breaking the fight, the second complaining witness was struck on the shoulder, causing pain.
But we only have the assault on the gentleman, correct?
The assault's only on the, I'm sorry?
The gentleman.
I believe so,
You
yeah.
only got one count.
Yes, Your Honor.
Okay. Ms. Blewett, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, man. Do you have the ability to hire a lawyer?
Court appointed lawyer, court appointed.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda's going to give an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Can you file no contact, no weapons, please?
Yes, Your Honor. So no contact, no weapons?
Yeah. Good morning, Mr. Delaney. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and
Okay, pause here. 76 grams of marijuana. That's not just a little bit of weed. In Texas, that amount bumps the case up from minor possession into territory where jail time is very real. What do you think? Should nonviolent drug offenses still carry such heavy consequences, or is the system overdue for reform?
a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer responded to a trespass at a gas station known for being a drug trafficking hotspot. Law enforcement officers witnessed surveillance footage of the defendant making multiple hand-to-hand transactions and throw something in his vehicle when the law enforcement officers originally approached the gas station. The law enforcement officers detained the defendant and approached the vehicle and witnessed 2 sacks of marijuana on the passenger floorboard area in plain view. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Mr. DeLay, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks, and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay. Deputy Miranda's going to give you an application. I'll have you sign a receipt, Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand? Okay, come on. What, you said 15?
He obtains GED.
What's
He
your,
obtains GED.
Yeah, but pay 15?
Oh, I'm sorry, Phillips is on page 15.
Yeah, okay. You're, Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant stated he was at the food store reversing out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So can you run his license, please, just to make sure?
Yes, Your Honor. I'm just not showing the driver's license numbers, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is a promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, you can be facing an additional 6 months in jail on a contempt charge. Every time you drive, it's an offense in and of itself. Do you understand? What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad had recently passed away.
You have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Robert Shelby and the holdover, you wanted to, Bill Stratton had to leave. You wanted to.
You mind? Yeah, please. So I'd like to do PC. I just want to know, because it's a DWI second, there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sure.
When he comes out.
Yes, sir.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able to, at that time, to do conditions, but I want to put bond conditions on.
Whoa, 117 miles per hour during a chase? That's not just reckless, that's a ticking time bomb on the highway. And this is why the judge is hammering down with ankle monitors and interlock devices. Judges often balance one thing above all else: protecting the public. Do you think this punishment is tough enough, or should repeat DWI offenders lose driving privileges for life?
On you, because you now stand charged with a driving while intoxicated second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in prison in the Texas in the TDCJ. So can you please give us? You have the right to remain silent. Anything you say can or will be used against you, sir.
On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weave between vehicles in an unsafe manner, and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The SEO was read and the defendant refused. The blood warrant was executed and blood was collected.
Can you run his license, please? See his license.
Yeah, he doesn't know. So,
At 117 miles an hour, Mr. Shelby, I'm now taking away your privilege to drive. I'm appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive
Yes, sir.
at all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will revoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir. So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within
Right.
3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a scram device.
It's a device that goes on your ankle so that we detect through perspiration whether you
Yeah, yeah.
are consuming.
Drugs.
All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with Felicia and then.
Thank you, Judge.
All right. Thank you so much, Carl. I appreciate it. You sure you want to do this?
As we talked about probation, we talked about the
You
different
have no
choices they have.
convictions. You have no as far as I see, no convictions. Now, after today, you're going to end up with a conviction on your record. From now on, you're looking at 90 days in jail for any new cases that you pick up, you know?
The choice is, you can get the defer, you can get the probation that we talked about, but you decided to do the time.
When you plead guilty to something, it goes on your record and it stays there for the rest of your life. You can never take it off. And it will affect you when you try to get a job, try to buy a house, try to get a car, a loan for something, try to get an apartment. So that's what I'm saying. I mean, you're old enough to know that.
I was lost when you was like 90 days at the.
No,
I was lost because.
No, what I'm saying, you pick up anything else in the future from now on, it's a minimum of 90 days if you take this deal, because they can enhance your punishment to a minimum of 90 days in the future.
You're not getting that as a time served deal. The
I'm
judge is
served here, but what I'm saying is, you don't want to defer to try to keep it off. You just,
Sir, if you look at the computer, I've been in TDCJ before. It don't matter. It don't matter.
That's,
I'm just gonna be
That's like
honest
this.
with you. It don't
I
matter.
don't see, I only get access to Harris County because I can't get them to give me access to anything else anyway.
I
So,
understand, but I can tell you, and I
Okay.
at my time, I done did my lesson. So if time served, I don't have to go to jail. I don't have to look over my shoulder. That's fine with me. I walk a straight line. That just was a unfortunate happen with my problem.
you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. Like I said, this is going to go on your record. It'll be there for the rest of your life. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, that's it.
I understand.
This is what you want to do.
Yes, sir.
How do you plead to the offense?
I plead guilty.
I'm going to find you guilty. I'll follow it. Good luck to you, Mr. Pack.
Give me
Take
one
care.
second, get you this piece of paper, go downstairs so you don't have to go.